Hello, I'm Nico, and after a long summer, welcome back to Debate Clash. We are dedicated to providing forensics resources for all students that need them. If you want to learn, you should have the ability to. The Debate Clash YouTube channel currently has over 400 subscribers. A shout out to all you awesome people that have subscribed to our YouTube channel. Now, in this video, we'll be going over the September-October Public Forum Resolution resolved. In United States public K-12 schools, the probable cause standard ought to apply to searches of students. Hefty. We'll start by defining what the resolution is talking about, and then going into the major arguments that you'll be seeing these next 2 months. Keep in mind that this video is for brainstorming purposes only. Please do not use Debate Clash as a source when you go into your rounds. The first portion of the resolution in United States public K-12 schools identifies that we will be talking about public schools that are inside the United States. Simple enough. As the affirmative, you do not have to defend private schools implementing the probable cause standard, and you do not have to defend anything on the international scale. The second portion of the resolution is a bit more complicated, the probable cause standard. Now, the Fourth Amendment outlines that you are safe from searches that are unreasonable, unless probable cause exists. The Fourth Amendment is the probable cause standard's father. Their family, they don't want to be separated. Make sure to look up the Fourth Amendment, print it out, and have it with you in rounds. I would love to tell you exactly what probable cause is and the standards that you need to meet it. However, there isn't really a solid definition for probable cause. Kind of awkward for the law not to be defined all the way. But what do we do when laws are confusing? We turn to the courts. Now, unfortunately, the Supreme Court also hasn't created a great definition of what probable cause is. They have even come out and said that probable cause is subjective, that we need to look at each specific instance to detect whether probable cause exists. It's very important to this resolution to look up various court cases and see what the Supreme Court has decided in the past. In its most simplistic form, probable cause exists when there is a fair or good chance that a search will result in evidence of a crime. This is different than the status quo, as right now they don't need probable cause to search your backpack or to search your locker. Currently, school systems rely on reasonable suspicion, essentially a lower standard to search students. The next part of the resolution, ought, can also be defined in an abundance of ways. However, the most common definition that I've seen in past topics of this word is that it's asking us what is the most moral or ethical thing to do. Applies to searches of students is a bit broader than its initial appearance. This can be defined to be searches of the actual student, searches of their backpacks, their lockers, and could even be argued to say searches of their cars or their phones. The resolution in a nutshell. The affirmative thinks that the standard for searching students right now is too low and should be heightened. We should have a better reason for searching students. The major affirmative arguments this month can be classified into 4 categories: legal, moral, impact to society, and finally, the workarounds. Let's jump right into that first category. We know the probable cause standard comes from the Fourth Amendment. Now, what doesn't exist in the Fourth Amendment is a clause that reads, "This constitutional right doesn't apply if you're in a public school, or if you're a minor, or if you're wearing a Donald Trump hat." The probable cause standard in the Fourth Amendment exists regardless of who you are and where you are. Or at least, it should. Let's look at a court case that actually backs that opinion up. In the incredibly controversial Supreme Court case, Tinker v. Des Moines, the court upheld students' abilities to wear a black armband to protest the Vietnam War in public schools. Why? Because they have freedom of speech, just like you, just like me, and just like the Trump. This case is now a precedent, and it identifies that minors are allowed to execute their constitutional rights while in school. If the court upheld the First Amendment in public schools, they ought to uphold the Fourth as well. You're going to want to read up on this case. It revolutionized students' rights in public school. Just like Debate Clash is revolutionizing the resources for the debate community. But seriously, hit that subscribe button. Another interesting part of the education system that should be observed is that most of these K-12 students don't have an option of whether to attend a public school or not. And in the status quo, that means they don't have a choice of exercising their Fourth Amendment rights or not. They're being forced into a public school, an environment that takes away their rights. Not cool, government. Not cool. Some negative teams may argue, well, if students don't want to give up their constitutional rights, then they can go to a private school. And they are absolutely correct. The only problem is that the students that can go to these private schools are the affluent ones. Building a system where poor students are forced to give up their rights and rich ones get to keep them simply breeds unfairness, spits in the face of equality, and is probably pretty immoral. Speaking of morality, let's jump into the second category. Remember, the resolution is asking us, what ought we do? There are numerous definitions that link ought to ethics, to values, to morality. Find one or several of these. Just like presidential Republican candidates, you can never have too many. Now, once you have a definition of ought implying a moral decision, we can use that to supercharge all of the arguments you're about to hear. The first argument in this category is that without probable cause, students' rights to privacy are infringed. With a nice vague definition of reasonable suspicion, administrators can check your locker, your bags. Heck, they can even check your student emails. You can ask Clinton how obnoxious that is. You should be able to go to school without being frisked at the door, or your bag emptied anytime an administrator wants to check your bag without any justification. It is not moral to force students into an environment like this, and it is not moral to take away a student's right to privacy when there is clearly no danger. This can be a great argument if run correctly. Define the resolution as a moral question. Give several warranted reasons why privacy is the most important value to cherish. Show how privacy is being infringed in the status quo. And finally, show how probable cause will come in and save the day. Along those lines, one can also argue that students' values and beliefs have been infringed without probable cause. This could be forcing a student to remove a religious article of clothing without having any justification to search them. Because administrators don't really need a reason to search students, one could argue that this could promote or perpetuate racism. They aren't questioned. If students are being searched more due to the color of their skin, then reasonable suspicion without probable cause is probably to blame. There is also a branch of philosophy called epistemology. Hey, that rhymes. Epistemology, in a very simple form, questions where knowledge came from and how we attain it. This could be a very interesting branch of philosophy to look into. What are the effects of taking away a child's right to privacy? What does that teach them? How will that change their behavior? Is this moral to do? The first thing probable cause does is increase the legitimacy of police officers and school administrators. They won't be searching students unless they have probable cause. This could increase the student-police relationship within schools, and could arguably decrease crime overall. Probable cause also decreases the amount of students that are expelled or sent to juvenile detention for low or no harm crimes. Maybe a student just got back from camping and had matches or a lighter still in their backpack. An unwarranted search might find these in a student's bag, forcing them to be expelled, to be treated like a criminal, and sent to a juvenile detention center. That student's life is going to be drastically different. This may be an exaggerated chain of events, but I encourage you to look up stories or statistics about these detention centers. Are there unwarranted searches that cause students to go to them? And once they attend, do their lives change? What happens to their behavior? There is also this argument going around that without probable cause, a student's perception of their rights becomes askew. If you're young and in school they teach you, don't exercise your constitutional rights, that may lead to you not exercising your rights in the future. Voter turnout might increase with the probable cause standard in place. Individuals, if they're raised to exercise their constitutional rights, maybe they'll be less likely to infringe upon others or be abused by the system themselves. Essentially, you can get any impact you want that's an extension of individuals exercising their rights. This type of argument will be very hard to run. You've been warned. A lot of the arguments in this section addressed the top-level links. It's your job as a debater to bring these down to an impact level. Really tell the judge how these things affect our education, our crime rates, our perception of our rights, and our society overall. The first workaround argument that you can make is that the affirmative's job is to simply prove that probable cause is better than the status quo. The resolution isn't asking us whether probable cause is the best solution or alternative to all of our educational system problems. It's asking us, does probable cause have a positive effect on education? This is a great framework argument to start your round with. It lightens the burden that the affirmative has while preemptively rejecting the negative's ability to bring up alternatives or counterplans. As discussed in previous sections, you can also define ought as a moral framework. This will help supercharge your privacy, beliefs, or racial injustice arguments. You can also argue that the resolution isn't asking us about the enforcement of probable cause. The word ought implies that we're talking about whether probable cause is a good idea or not. We're not talking about how it will be implemented or how it should be implemented. Negative arguments can also be classified into the same four categories: legal, moral, effects on society, and finally the workarounds. Everyone has heard some variation of the phrase, you give up rights to get rights. When you go to the airport and take off your shoes, let them screen you, you're giving up your right to privacy, but in return, you're getting safety. This is the mentality that schools should have. Students are obligated to go to school, so the government ought to protect them. These buildings should be 100% safe. The government's first priority is to protect the people. Let's not forget that just because some students find that it's inconvenient to have their lockers searched once every other month. The other argument that you can make is a large majority of these students in K-12 schools are minors. That means if they bring a weapon to school, they're not going to be tried as an adult. If these minors don't see the full effect of the law in the punishment side of the spectrum, then maybe the constitutional rights side of the section, specifically the Fourth Amendment, should be limited in certain areas. There's probably a much prettier way to phrase that, but hopefully the concept got across. One could also argue that these lockers that the students use are legally the school's property. They shouldn't need probable cause to search something that is legally theirs. This concept could also apply to searches of students' cars that are parked in the school parking lot, or the desks that the students utilize on a daily basis. It should come as no surprise at this point that ought usually implies morality, so let's see what the negative can do in this area. First, because the negative is pushing for staff to be able to search students with less reason, this inevitably means more searches, which in turn links to more security. A good debater can turn more security into lives saved. Lives saved is a pretty solid moral argument. To assist with the life arguments, many debaters will bring up the probably overused but oh so applicable branch of philosophy, utilitarianism, or the greatest utility for the greatest amount of people. One could also argue that probable cause changes people's mindsets and forces administrators into perceiving students as criminals. If I'm an administrator and I think that a student might have a weapon in their backpack, instead of just checking, I have to legally think in my mind all of the possible reasons why this student is suspicious and give myself warranted reasons as to why I should be able to check his backpack. Creating a system where administrators and police have to justify their searches of students to an enormous extent might just change the mindset of these school staff to one that probably isn't very good. Along these lines, race, gender, religion, these are all variables that could play a part in the administrator's thinking process. Probable cause, once again, allows an administrator or police officer to think about these variables before searching a student. Bringing these types of variables into the equation is definitely immoral. With probable cause decreasing the security measures that public schools take, this could also lead to an even bigger inequality between the rich and poor. Private schools would become much more secure, while public schools did the opposite. This is very unfair to promote this type of inequality and to put a price on a child's life. With probable cause, there are strict regulations. When can I search a student? When can I not? When is a warrant needed? When is a warrant not needed? This could lead to a lot of confusion. And not the I just woke up after a 3-hour nap and I don't know if Batman is my roommate or not kind of confusion. Legal confusion means educational officials and police officers getting into trouble. Legal defenses add up very quickly. Organization in the classroom could decrease, as some teachers will be suspended for not following this arbitrary probable cause standard. And all of this money to correct these actions gets taken out of the education budget. This could also lead to less crimes being caught. Staff will start to refrain from searching students so as to not undermine the probable cause standard. With less crimes being looked out for, it means that the chance that a student would commit a crime will skyrocket. Along the lines of security, some probable cause searches may require warrants. By the time an officer can go get a search warrant, the damage may be already done, sometimes in lives. And finally, cyberbullying might increase with the probable cause standard in place. The chance that a student would ever have their electronic devices searched would definitely decrease with probable cause, meaning the risk for cyberbullying someone would also decrease. The affirmative has to defend a resolution that includes all searches of students, not just some. You as the negative could technically argue that just students' cars, or just students' lockers, or anything that isn't school property should be required to have probable cause, but everything else, reasonable suspicion. Although this framework might sound fun, you need to be very good at the framework debate in order to win off of this. It could also lead to some pretty bad blurry rounds, which no one likes. One could also argue that the resolution isn't asking us about the implementation of probable cause. It's asking us, probable cause as an independent variable, is it moral or not? Following that path, one could argue that probable cause is just too blurry to be fully defined as a moral concept. It's like me saying, humans are moral. Okay, that's pretty vague, and just like probable cause, each human is different. Each probable cause situation or case is different. You can't fully determine something as moral if it changes from time to time. And even if your opponents found a way to magically determine that probable cause was always moral, is it still moral to force staff to use an unclear definition of when they can and can't search students? The first tip I have is to define probable cause in cross-examination. In order to have a good round for you, your opponents, and especially the judge, probable cause needs to be defined to some degree. Establish this in the first cross-examination so that all of your other speeches can also be good. The second tip that I have for you is to talk to your LD friends. They are used to debating morality. Converse, pick their brain, and get lots of arguments. The third tip I have is to ask questions. Just looking up this topic online, I found acronyms galore. Don't be afraid to admit that you don't know off the top of your head the crazy branch of philosophy that they bring up, or the jargon or acronyms they use. If you don't fully understand a point, you can't defeat it. The fourth tip I have for you is to know how to debate framework. Because this topic is so unclear, determining the winner will rely on clarification in the framework. If you don't know how to debate framework or you want to get better at it, I did recently release a video. Feel free to check it out. Thank you so much for watching this video. If you want to support us, please hit the subscribe button, share this video with your friends, it will only help them, and also tell your debate coach, we sell files at debateclash.com. If they want to purchase files like Champion Briefs, PF Debate, Debate Doctors, they can head over to our marketplace and purchase the evidence they already buy there. Thank you so much again for watching, and good luck at the beginning of this wonderful season.